I'd like to thank the Enoch Cree First Nation and conference organizers for hosting us here. And I'd like to focus my comments today on a question that was addressed from a few different angles yesterday. So the status of Crown sovereignty, and in particular the significance of the fact that the Supreme Court has in various ways called into question the legitimacy of Crown sovereignty. And my aim is to give an overview of what I think is going on in the court's Section 35 case law and of the avenues that it opens up for gaining greater leverage, bargaining power for First Nations, and expanding Aboriginal and treaty rights under Section 35. So the focus of my comments is quite narrow in that sense. I mean, I'm working off what the court is saying in its case law. I'm not necessarily endorsing what the court is doing, but my comments are narrowly focused in the sense that they're really feeding off of what's happening in the court. Now, to my mind, one of the most striking features of the court's modern Aboriginal and treaty rights case law is the shift from substantive justifications for Crown sovereignty to what I'm going to call procedural legitimation of Crown sovereignty. And I'll try to explain briefly what I mean and why I think it matters for the court's Section 35 framework. So in the late 19th and early 20th century, Canadian judges often spoke freely about the uncivilized status of Indians and would rely on that to conclude, for instance, that treaties were not legally enforceable, they were political trusts, not legal trusts, that Indian title, again, was not legally enforceable. It was a matter of sort of a sacred bond between the Crown and Indians and not a matter for the courts. In recent decades, the Supreme Court has explicitly rejected that reasoning. So in 1985 in R.V. Simon, for example, the court rejected the language of Justice Patterson, who in a 1929 case described the Mi'kmaq as uncivilized and concluded that for that reason, quote, "the savages' rights of sovereignty, even of ownership, were never recognized." More recently in 2014 in Chilcotin Nation, the court stated that the doctrine of terra nullius never applied in Canada. So in other words, the court has clearly rejected the kinds of justifications that were given historically for Crown sovereignty. So it would seem to follow from the court's statements in Simon and Chilcotin that there is no legitimate basis for Crown sovereignty, at least in the absence of treaties that would allow the Crown to share the land. And the court seemed to hint at this conclusion in decisions like Taku River Tlingit and Haida Nation in 2004, speaking of the de facto sovereignty of the Crown and of the need to reconcile pre-existing Aboriginal sovereignty with asserted Crown sovereignty. But as commentators have pointed out, the court strikingly says in the very same paragraph in Chilcotin, where it says terra nullius never applied in Canada, that with the assertion of European sovereignty in British Columbia, underlying her radical title to all land in the province was the property of the Crown. So what exactly is going on here? What's the court thinking when it tries to hold these two seemingly very contradictory statements together? I'll give my interpretation of what the court seems to be doing with the aim of finding a clearer picture of what might be possible in the Section 35 framework as it currently exists. Now, the court said in Haida and reiterated in Chilcotin that the Crown has both a moral and a legal duty to negotiate treaties where there are outstanding claims and asserted rights. In other words, the Crown has a legal duty to perfect its assertions of sovereignty where it hasn't already done so through treaty. And as I suggested to Professor McNeil yesterday, to me this move by the court strikes me as very similar to a suspended declaration of invalidity. The court will quite often find a law unconstitutional, or even, as in the case of the Manitoba Language Rights Reference, all provincial laws unconstitutional, but give Parliament or the provincial legislature some time to fix the problem. In the meantime, it might grant constitutional exemptions, but otherwise will act as though the law were still valid. So an example right now is the sex discrimination in the registration provisions of the Indian Act. There's time given to Parliament to fix the problem identified by the courts. And I think the court had something similar in mind in a number of Aboriginal title cases, notably Calder and Delgamuukw. So the court in those cases did not declare Aboriginal title over specific territory, but essentially warned the government that there's a problem with Crown sovereignty and told the Crown to negotiate. When successful negotiations largely failed to materialize, the court in Haida began imposing procedural obligations on the Crown when it exercised its de facto sovereignty in a way that would interfere with asserted rights. And the court in Haida stressed that the duty of consultation and accommodation that it declared in Haida was applicable in cases of asserted but still unproven rights. So it distinguished that clearly from the fiduciary duty that applied, according to the court, in the case of established rights. And the court said that the Crown did not have to reach agreement in the case of asserted rights about the level of consultation and accommodation required in any given case. Where the rights were asserted but not yet proven, the Crown could act in the face of disagreement. So here's the basic picture as I see it. The court has acknowledged that the Crown has a real sovereign legitimacy problem, but the court is giving the Crown time to get that resolved. And in the meantime, the court has said it will itself weed out bad exercises of sovereignty from good or legitimate exercises of sovereignty. And the court is doing that by imposing procedural obligations on the Crown when it exercises sovereignty, which is what I mean when I say the court has moved from a system of, or from substantive justifications for Crown sovereignty to procedural legitimation of Crown sovereignty. So I think here it might be worth taking a step back and ask why. So how did the court get to this position where that's the role it seems to be taking under Section 35? And I think in this sense, the court has been quite transparent about the fact that it's grappling with clashing political visions. So on the one hand, you have the vision that's typically endorsed, at least at the level of rhetoric among governments and courts, et cetera, of a nation-to-nation relationship with First Nations that acknowledges their prior sovereignty. And on the other hand, you have a vision of unilateral Crown acquisition of sovereignty. And the court has placed itself as the arbiter of these visions, hoping to find some set of procedural safeguards that will bridge the difference. And I think it's not really a promising task in the sense that the underlying political conflict is not easily resolved through legal doctrine. But since that's the current framework established under Section 35, it's important to take a look at the details of the procedural safeguards that have been set up. They're the expression of the court's current provisional resolution of this clash of political visions. And to my mind, there are two glaring weaknesses. First, the Crown fiduciary duty that applies in the case of established rights has itself been reduced to procedural safeguards and assimilated to the duty of consultation and accommodation. And I overstate a little bit here, but I don't think by much, and I'll explain what I mean in a second. Second, whether we're dealing with claimed or established rights, the Crown has the power to act in the face of disagreement. The court has done nothing to stop that, and I think that's a source of huge negotiating imbalance, which is something the court has said it wanted to rectify. So first, the proceduralization of the Crown fiduciary duty. The court declared the Crown fiduciary duty in Guerin, grounding that duty in the Royal Proclamation of 1763. As the court explained there, the Royal Proclamation set up a regime of voluntary land surrender. So under the Royal Proclamation regime, a First Nation, if it chose to do so, could sell land to the Crown and only to the Crown. And the court said in Guerin that monopoly the Crown gave itself over purchasing Indigenous land meant that it had a fiduciary obligation to deal with any surrendered land in the best interest of the surrendering group. So as described in Guerin, this is a real fiduciary duty. It's what you would see in the private law. The court in Guerin, though, accepted in the background, because it wasn't relevant to the case, that Parliament could, if it so chose, just extinguish Indian title. Because it wasn't relevant to the case, the court didn't have to address the contradiction of a fiduciary who could just extinguish the interests of its beneficiary. That contradiction came to a head in Sparrow in 1990. So in Sparrow, the court essentially reduced the fiduciary duty to a minimal impairment test, saying that the Crown has the power to act under Section 9124. When it chooses to act, we should impose a kind of proportionality requirement, and it should not infringe Aboriginal treaty rights more than necessary to achieve its purposes. Now, the court in Chilcotin stated that before title is established, the Crown has procedural duties under Section 35. But after title is established, it has substantive duties as well. So in Chilcotin, the court tried to hold to this distinction between asserted but unproven rights and established rights, and say that we have procedural duties in one case and then fiduciary substantive duties in the other. But I think the distinction is extremely unclear and unconvincing. Even in the case of established rights, there's nothing in Chilcotin, despite language that would suggest otherwise, that would stop the Crown from acting in the face of disagreement. So if the Crown has a proposal for action that would infringe or affect land that is held by the Chilcotin Nation under Aboriginal title, and the Chilcotin Nation did not consent, and moreover said to the Crown, we don't think you can justify the infringement, there's nothing stopping the Crown from saying, that's fine, we think we can justify it, if you want, take us to court. And so this is very similar to the Haida spectrum. And in Chilcotin, the court said if that kind of case came to court, we would be at the level of a proportionality analysis that is echoed in Haida. So it's a little hard to see the difference between the case of established rights and claimed but unproven rights. And most recently in Clyde River, the court directly applied the Haida spectrum to the case of established treaty rights and had no hesitation in saying, well, the fact that they're established rights puts us at the strong end of the Haida spectrum. It just didn't seem to strike the court that this was not in line with the distinction it set up in Haida. But most important in all of this, the Crown can act in the face of disagreement in all cases. So there are First Nations that are overwhelmed with project referrals, facing the burden of initiating court action to get a review of proposed activity that will infringe their rights. And this is a very weak check on de facto Crown sovereignty. If the court is ready to question the legitimacy of Crown sovereignty, and to impose procedural safeguards, then it shouldn't be a step too far, at least in the case of established rights, for the court to ensure those safeguards are met before the Crown action that infringes those rights. In other words, I think that's justifiable and justified on the case law as it currently exists. And I'll just close with a case I like to point to in this context. In the reference on provincial judges' remuneration, the Supreme Court was faced with the question whether provincial legislatures could reduce judges' salaries as part of broad public employee rollbacks. And the court in that reference held that the unwritten constitutional principle of judicial independence required provincial legislatures to create independent commissions that would review judges' salaries, and that provincial legislatures could not take any action to reduce judges' salaries without first consulting those commissions. So if the court can find a constitutional principle to impose a prior mechanism of review in the case of judges' salaries, I think that the principle of nation-to-nation relationships would do just fine in the context of Section 35. Hi, thank you.
Thank you to the organizer of this extremely thought-provoking conference, and thank you to our host, the Enoch Cree Nation. I propose to make an argument that there are big gains to be gotten from thinking of Section 35 as predominantly a modern source of obligations. And I'll be making the case that as Section 35 interpretation has grown, it has moved from consideration of discrete rights to a deeper, richer web of duties and obligations that I will argue provides an adequate foundation for meaningful reconciliation. Now, it's a challenging exercise to make this case in 12 minutes. What I'm going to try to do is do it in 3 ways. First, I'm going to place my claim against the context of more common theories in literature about the role of Section 35. And then I'm going to just briefly summarize what I think a modern theory of Section 35 entails. And finally, I'm going to give you a list of things, very specific things, that can be gained by thinking about Section 35 in a modern way. Now, what are the 3 normal ways that you see Section 35 described in literature? Because I acknowledge that my view is a minority view. First, Section 35 is seen as flawed precisely because it is placed within the Canadian Constitution. Second, Section 35 is flawed because it rolls back what would otherwise be the protections offered by the existing and evolving common law prior to its enactment. And third, Section 35 is flawed because it generates relatively ungenerous interpretations of Aboriginal and treaty rights. A fourth form of critique has recently emerged, and it's a very powerful critique that I will not be able to address fully. It's John Bohr's idea of Aboriginalism. And there are many structural similarities between the arguments that I will develop and the model that John develops, but I won't have time to address it fully. So let's start into, first I want to list 7 structural reasons why the jurisprudential framework is best seen as predominantly modern in nature, and I'll just read them. Section 35 rights are consistently contrasted with common law rights. Section 35 rights are almost invariably described as modern rights. Proof of a common law right is described as sufficient but not necessary for the existence of a Section 35 right. The methodology that's consistently developed for determining Aboriginal rights and treaty rights is empirical and methodologically retrospective. It is not a search for the common law of the past. Nidal interest, in fact, is shown in the traditional categories of the common law: ceded, conquered, settled territories. There are strong indications that the declaratory theory of the common law simply has no application in the field of Aboriginal rights. And finally, and most importantly, the jurisprudence points towards a dialogical form of engagement between the Crown and Indigenous peoples that I would argue is the very heart of Section 35. Now let's go back to the 4 dominant theories that I'm arguing with, I'm presenting an advocacy case. First, Section 35 is flawed because it's part of the Canadian Constitution. This is part of a bigger argument about flaws in the original establishment of Canada. Flaws that are based on doctrines of discovery, terra nullius, inappropriate recognition and incorporation of Indigenous legal systems. A modern approach to Section 35 takes a slightly different view. It accepts that there's a stain on the existing legitimacy of Canada, but doesn't accept that Canada as a sovereign nation somehow is limited in its application of laws. In other words, Section 35 of my theory has full reign. However, legitimacy is something that must be continually, daily, and with great difficulty earned. And we're in the process of earning legitimacy through rebuilding our relationship with Indigenous peoples. So that's the first fundamental point about a modern approach to Section 35. The second argument is Section 35 is flawed because it rolls back protections that otherwise would have been provided by the common law. Kent McNeil and David Yarrow, I guess now 15 years ago, made that case quite persuasively. However, after looking at the legal history, I have formed the view that the New Zealand School of Legal History has it right, that though there's a connection between the common law that we're elaborating now and what happened in the past, they're different in kind. The common law in the 18th and 19th century was considerably less generous than is possible now under Section 35. So, I'm arguing that Section 35, almost like Bruce Ackerman talks about as a constitutional moment, offers a stronger foundation for reconciliation than the common law. The third one I want to dwell on, the idea that Section 35 has generated some very ungenerous interpretations of Section 35. Vanderpeet, Pamajuan comes to mind. My argument will be, as Section 35 enriches and moves more towards a dialogical foundation, the resources are there to present much more even-handed and less asymmetrical visions of Section 35. The final one, John Borrow's Aboriginalism, it's a powerful critique. He argues that Canadian methodology under Section 35 is linked to originalism and that we should move more towards a living tree approach to Section 35. As I said, it shares some structural similarities with the picture I'm painting, but it comes to some very different conclusions about the content of Section 35. I'll give 2 examples that I think illustrate how the Supreme Court of Canada is in fact moving to a modern paradigm. The best example is the Manitoba Métis Federation case. This is the case that dealt with a failure to diligently implement the land provisions of the Manitoba Act. What's striking to me is rather than looking at the content of the common law, what would have bound the actors at the time, the Supreme Court of Canada is quite clearly crafting a series of modern obligations based on its assessment of failures in the past. And it uses the evocative phrase, fixing rifts in the national fabric. So this is part of the modern function, in my view, of Section 35. The second, and Ryan touched on some of these issues, is the issue of how we are growing in our understanding of Aboriginal title. What is striking to me about the Chilcotin decision is that there is a firm distinction between the obligations that the Crown owes prior to establishment of an Aboriginal title and after establishment of an Aboriginal title. And what is really quite striking, that Aboriginal title, like all Section 35 rights, are fundamentally prospective, and they're very strong rights. I think we could have a good discussion about how limited the Crown's authorities are in fact when an Aboriginal title is found. But we'll save that for perhaps later. So that's my reaction to the four competing theories. But what is the essence of a modern theory? It's the shift from rights to obligation and duty. You know, what we've seen in the last decade is a proliferation of deep and meaningful duties that are grounded in Section 35. Not just the duties to consult and accommodate, not just the duty to negotiate, the duty to implement constitutional provisions, duties to delineate are coming. I think duties to seek reconciliation are around the corner. Just the Haida decision itself, a great example of poetic constitutionalism, sets out many possible duties that can help guide the parties towards success. And it's this facilitative function of using constitutional norms to guide the parties in a direction that wasn't achieved properly at the start is, I think, the dominant characteristic of Section 35. So, what does a modern approach make possible? Perfect, 5 minutes. I think, most importantly, and we're only starting to fully understand the magnitude of this obligation, the parties have a duty to negotiate, and not just to have negotiations, but to work out different ontologies of connection to land, connection to place. I think that's implicit in a deeper understanding of the Section 35 jurisprudence. It certainly places pressure on past practices of rights neutrality. Negotiations now about land must involve real discussions, and the Clyde River decision makes this crystal clear in my view, as did the Gateway decision from the Federal Court of Appeal. Beyond that, Section 35 provides a strong incentive framework to think more creatively about accommodation. I don't understand how in the Section 35 era we can't be talking about resource revenue sharing, co-management, meaningful joint involvement, you know, where land is the issue. Land is always the issue. I think really interestingly, Section 35 provides a framework for a relational theory of treaties that I think is lacking in the common law. The idea that Section 35 can provide a carapace of protection around the treaties. We see this in Mikisew and Grassy Narrows, where the parties have a relationship and the courts are going to ensure that that relationship is expected. This kind of thinking is only made possible, in my view, because of a modern approach to Section 35. I think it provides an opportunity for us to break logjams on self-government. I have made the argument that Section 35 houses a right to have and maintain an Indigenous legal system. Section 35 is the source of, I think, deep respect for multilateralism in Canada. It provides a strong foundation for an ethos of justification, which is at the heart of any proper theory of constitutionalism. As title develops, as more and more title cases are negotiated, established in various forms, I think it's going to be clear that this provides a strong foundation for meaningful self-determination. And we have a model, I think, with a modern approach that allows us to think about how we incorporate Canadian domestic law with other sources of inspiration, including the Declaration and the work of various royal commissions in Canada. So to conclude, a modern approach to an understanding of Section 35 is obligations-based, and it provides a fresh way of thinking that allows us to move away from the strictures of Van der Peter and Pamajuan, to think more deeply about the kind of relations we wish to have in Canada. It's less about respecting claims, as I said, but respecting the fact that we all have different connections to this land, and in my view, equally strong connections to this land, but that we have to work them out together. And I think Section 35 does provide an obligation structure that I'm going to have a minute to spare. This is good. So, to conclude, I think Section 35, this is not something that's going to get worked out in the courtroom. You know, the meaning of Section 35 is going to be worked out not only at negotiating tables, but in the discharge of these duties, like the duty to consult and the duty to negotiate. It's going to be worked out through policy development. It's going to be worked out through co-development. But the work of the Supreme Court of Canada in setting the obligation structure is a permanent part of that. And I think it's the lasting legacy of the Supreme Court of Canada in contributing to fixing, the moral flaws of Canada's original foundation. When I think back at this conference, and it's been a very strong conference, but one of the most evocative moments for me was the beautiful moment of hearing a very familiar prayer in the Cree language. I mean, that was a very powerful moment for me, and I suspect many of you felt the same way. It reminded me, and because I love music, songs kept going through my head as I was listening to this. And I saw Boney M on Thursday night. And there's one phrase that kept coming back to me all through this conference. You know, they're a reggae disco band, who I think are among the great philosophers of the world as well. And in the song By the Rivers of Babylon, there's this phrase: how can we sing the Lord's song in a strange land? Canada's a very strange land. And I was also struck by Mark's comment. I'm going to shift it slightly. We live in a strange land of multiple legal universes. So my contribution is to try to add to that pluriverse by suggesting that Section 35 should be taken seriously as a legitimate foundation of reconciliation. And I love the idea of dropping the empty full box metaphor. From now on, it is always going to be, for me, a living ball of energy. Just love that analogy. So to close, my basic case is that Section 35 should be taken seriously. There are critiques. We've heard serious critiques from Ryan. I think they're answerable, but the answers don't matter. It's the dialogue we'll have about that that matters. And I'll close by saying, if we want to have poetic constitutionalism, we need not just big M in our Constitution, we need bony M as well.
Meroltiok, nín Dalhousie Naiomi Metallic, ach Dalhousie Listiguch, ach Weldasi Begis in Giskuk. My name is Naiomi Metallic, and I'm from the Listiguch Mi'kmaq First Nation in the Gaspé Coast of Quebec. I live in Halifax over 20 years now, Wahkohtowin, and I want to thank our host nation, the Enoch Cree, and as well recognize that we're on the territory of the Treaty 6 Nations. I want to thank the organizers for this conference and just say how much I've enjoyed listening to all the other presenters. I've definitely learned a lot. But the thing that the biggest lesson that I've learned is that the U of A is not in Calgary. And I will be reflecting on this lesson during my bus ride back to Calgary later on today in order to catch my flight. Thank you. Little Mi'kmaq humor and humility there. Anyway, you can tease me about it. I'll be okay with it. So my piece is not directly on Indigenous laws. A little bit about me. Before becoming a professor at Dalhousie, I practiced for about a decade, and I think because of that I've got a bit of a pragmatic side, and when I do engage, I often sort of engage at a doctrinal level. And so that makes me a little scared, being sort of the tables right here with the veterans of constitutional law. But if I do get something wrong or I'm completely derivative of some of your work, just please be kind. Personally, I believe very strongly that Indigenous people have the right to control their own destinies. And that I think that's something that they've largely been deprived of for the last 150 years. And so a lot of my work is looking at how to find space in Canadian law for Indigenous jurisdictions and laws. So today I'm talking about the constitutional rules around federalism. Federal people have spoken about it already, but federalism are rules in the Constitution about power, right? Who gets to decide and pass laws. And since 1867, Canada's Constitution has given the power over Indians and lands reserved for Indians under Section 9124 to the federal government. And we often understand this power to mean that Canada has the control and power to make decisions over Indigenous people and their lands. And that's how it's mostly been used during the last 150 years. But it's not the only way that it can be used. Both the 1993 Penner Report as well as the 1996 report of the Royal Commission on Aboriginal Peoples recommended that Section 9124 could be used in a positive way to recognize the inherent Indigenous right of self-government, and both reports suggested the passing of legislation under that power in order to facilitate the exercise of Indigenous self-government, as well as ways to address inevitable conflicts between the laws of Indigenous peoples and other governments' laws. And actually, this is how the law in the United States around the constitutional power over American Indians has been approached over the last number of decades. And it's in big part about how their courts have interpreted or approached that constitutional power. And the U.S. is not perfect, I'm not trying to say that, but in some respects it's a lot more advanced than we are in terms of the recognition of the inherent right to self-government. I guess what I'm trying to say is that we don't need a constitutional amendment to take a new approach or a more positive approach to 9124. And I think it's a matter for both the courts and the Canadian government to revision the way that we think about 9124. So when it comes to matters on paper, at least since July of 2017, this summer, we have the Government of Canada saying and committing to principles that would suggest that it is ready to revision 9124. So in their new 10 principles respecting Canada's relationship with Indigenous people, we've got Canada recognizing that all relations with Indigenous people need to be based on the recognition of self-determination and self-government. And even more interestingly than that, number 4 of these principles says that the Government of Canada recognizes that Indigenous self-government is part of Canada's evolving system of cooperative federalism and distinct orders of government. It's a more technical definition of cooperative federalism, and I'll talk about it a bit more, but generally it's this idea of making space to allow for lawmaking powers of different governments to coexist at the same time. So we've got the government saying this, and it'll be a matter of wait and see if actions will align with these words. But it hasn't been this way in the past, of course. So if I were to sort of give you the main themes of what Section 9124 jurisdiction, how it's been exercised in the last 150 years, I would say it would be inaction unless it's convenient for the federal government. For the federal government, we've got, I recently had to reread the Daniels case for my class last week, and it's very clear that one of the purposes of 9124 was for colonial expansion, and clearly it was used up for that point. And the Indian Act, and even the way Canada approached treaty making in some respects post-Confederation was to that purpose. But then for other reasons, there's a lot of inaction. So when it comes to Inuit and Métis, there's cases that show us that the approach has been largely one of denial. And when it comes to the First Nations or Indians, the only group that the feds has legislated with respect to, it's largely been a matter of neglect. Yes, there is the Indian Act, but the Indian Act, aside from some small amendments based on challenges to status, has not been substantively updated since 1951. And the legislative initiatives that we've seen have only been in the last 20 years and relatively sparse. We know that there's been significant gaps in jurisdiction. And interestingly, what happened in 1951 was essentially a deflection from the federal government to the provinces via Section 88 of the Indian Act. What was happening at the time, at least some of my other research shows to me, is that at this point in time is when we have the creation of the Canadian welfare state, right? And the massive increase of programs and services provided and legislative efforts in that regard, both at the provincial level and the federal level. But nobody wanted to legislate with respect to Indians. And in fact, there seems to be some evidence to suggest, and Carrie Wilkins writes a little bit about this, that 88 was in fact an attempt by Canada to sort of give control over the Indians to the provinces with this idea that they would be the ones who would be responsible for providing services. And the rationale at this time was based on a joint parliamentary Senate committee that was writing about the situation of First Nations and the extensive poverty in the communities and their need for essential services. Thanks. Anyway, essentially, 88 was an attempt to get the provinces to take it over, and it was very much in line with let's move them into the mainstream. I'll come back to that in a second. The other sort of major themes we see are diminishment of jurisdiction. So even today, in cases like the child welfare case and a number of other cases that have gone to take Canada to court over underfunding and other inequities, Canada argues that is not acting under 9124 when it funds or when it undertakes other activities, but rather it's just the exercise of its spending power. That wasn't accepted in the Caring Society case. And then another theme we see is this sort of resiling from treaty promises, and John Burroughs has wrote an excellent piece on that called Canada's Colonial Constitution. So we have the federal government, and on the provincial side of things, it seems that provinces tend to be okay with imposing their legislation so long as it's about burdens. So we see this a lot in the child welfare case context, where child welfare legislation with respect to abuse and neglect is applied. However, when it comes to programs and services even to assist parents or child welfare, social assistance legislation or various other things, many provinces actually have provisions within their legislation that say that it doesn't apply on reserves. And it's this constant sort of hot potato argument between the federal government and the provincial government. And it also seems that the provinces tend to be rather okay with, limiting Aboriginal and treaty rights. So that tends to be the main themes that we see. And as one of my students said last week in class, she said, it seems that the feds or the provinces really only want jurisdiction when it serves their own self-interest. And then when we look at the jurisprudence that we've had to date on 9124, and it just seems the rules keep changing, right? So we go from Section 88 to thinking that's the basis upon which provincial laws apply, to the Supreme Court telling us in R versus Dick that for the most part, provincial laws apply out of their own force and effect, and that it's only laws that impact the core of Indianness that really get into this issue around 88. And so on the other side of the ledger, we have this case called Sutherland from the 1980s, where we're told that any laws that involve the singling out or providing special treatment to Indians cannot be laws of general application. So those are off limits to the provinces. But then we start seeing cases like Catla in 2002, where the court limits this far more and telling us that, if legislation only refers to Aboriginal, that's okay. So really unclear about where the line is. And another more recent decision, Niltuo, the court praised legislation where provincial legislation that specifically accommodated or provided special treatment to Indigenous groups without actually getting into any of that singling out stuff, but kind of raises question marks. And then more recently, there was cases where the Supreme Court said that Aboriginal treaty rights go to the core of Indianness, and then more recently in Chilcotin and Grassy Narrows, we have them telling us that that is no longer the case, that we should stop looking at interjurisdictional immunity because of reasons of cooperative federalism, and that Section 35 is good enough to deal with that. I'm going to be a little rushed, but I'm going to try to go a little bit, just a minute or two longer on this. And I think there's a glaring oversight, and maybe this goes to Jean Leclerc's point from earlier that eventually the SEC might become entangled in its own conceptual nets. But when you look at Chilcotin and Grassy Narrows, I do think there's a potential glaring oversight, which is the fact that the court has never overruled itself on singling out, or this idea that, what is it to constitute a federal power? And it's told us that, now we just go with Section 35 to allow the provinces to infringe, and you look at the Sparrow test. But when you think about the Sparrow test and its application, the courts have said that, the Sparrow test is a comprehensive test that, the province has to accommodate the rights of Indigenous people within that framework. But, if you step back from that, you ask, well, how could the province accommodate those rights unless it provides some special treatment, or there's some singling out and actually mentions Indigenous people within its legislation? So I think there's a real problem there in that, in Adams and Marshall, the court suggests that there should be legislation that actually accommodates Aboriginal rights, so you avoid an unstructured discretionary regime. And I think just more generally, if you're looking at minimal impairment, if you have sort of broad scope legislation, you're going to impact on those rights. So I think there's a glaring oversight that the court's going to have to deal with at some point, and it's either going to have to say, throw out singling out as well, or come face to face with the fact that it's almost obliterated 9124 and think of a new approach to dealing with it. And I probably don't have a ton of time. Just quickly, give me one more minute. The court gives lots of reasons for why it takes the approach that it does. I think they're all sort of problematic in terms of it says that cooperative federalism is the reason for why it got rid of or doesn't look at IJI in this context anymore. And it doesn't see Indigenous governments as part of the, the three levels of government. We're not considered in that context. And so, and I'll just quickly go through, I can't go through these, but I'll finish on my last slide, which is, sorry. Yeah, the SEC doesn't recognize Indigenous peoples as forming a third level of government with inherent jurisdiction. And it has, the approach of the U.S. Courts has been far more generous in this regard. And, the ironic part of all of this is that the Supreme Court of Canada cases have adopted the approach that brought the U.S. to the approach that it has, which is the Marshall Trilogy from the early 1800s. And all of these cases are at the root of Canadian cases on Section 35, yet the court has never gone the same route as the American cases, and it seems to be because when the courts consider it, they only talk about Indigenous people and their relationship to land and not Indigenous people and their power or their sovereignty. And again, this is another place where I think the court's being completely unprincipled in that it's just looking at rights up to land and not looking at sovereignty. And I think these are two areas where the court's going to have to fess up to this pretty soon and really grapple with inherent jurisdiction much more. Thanks. Sorry, it was a bit rushed.
Thank you so much to our three panelists at this great conference. We do have a few minutes for questions. I'm going to take the chair's prerogative to ask the first one, and it is inspired a little bit by Jean Leclerc's keynote from this morning, in which he asked us to think about constitutional poetry, which made me think about the constitutional scholar and poet Frank Scott, who once said that the state is a work of art that is never finished. Now, some of you may think that's a pretty ugly garage sale painting if the state is a work of art, but one of the things that I like about the law is that it's always in a state of becoming. And so if I handed each of you panelists a paintbrush to make a stroke, a change, could you answer me quickly? What's a change that can and should happen to our constitutional law or structures or the document itself that might put us on a better path? Ryan, did you have any quick thoughts on that?
I was writing my email address for part of your question, so going off the last bit of it, constitutional change that would move this process forward. So, I tried to conclude with the suggestion. So, looking at the subject matter of my paper, and what the courts do under Section 35, I see the biggest problem for imbalance in negotiation or consultation accommodation that the Crown can always act in the face of disagreement. So unless you're a First Nation that has a lot of resources to go to court every time the Crown proposes to do something you don't like, you're kind of stuck negotiating, knowing that if you don't accept whatever's given to you, the Crown will just go ahead and permit or release or whatever as it wishes. So I would say there's a lot of questions. What would it look like if the court required review of proposed infringements before the Crown got to act? It could take place in the courts. You could have something modeled on New Zealand's Waitangi Tribunal, some kind of independent commission that would involve both Indigenous representatives and Crown representatives. There's lots of things the court could do, or ideally legislatures, Parliament could do, but I think some mechanism to review proposed infringements before the Crown is simply allowed to go ahead and infringe as it sees itself capable of justifying.
Ron, how about you? One change that you'd make? Yeah, you can have two.
I'm inspired by the missing member of our panel, John White, who called a constitution 1,000 acts of accommodation. And I think we have literally 1,000 possibilities. But the two I would single out, we scrapped the idea of claims and we developed both for gone, right? It should just be gone. We should be talking about reconciliation councils, in national areas and in treaty areas where representatives of the state meet with Indigenous peoples as equal and work out different ontologies, different ways of engaging with land. And it's somewhat different, I think, from how other people describe it, but that's the first thing I'd do. The second thing, I think the state should invest massively in the project of revitalization of Indigenous cultures and language. You know, if there's any process that could further enable the idea of reconciliation, it's that, because I presented a constitutional argument, but that's not where the real work is. The real work is in communities, and I think we should be supporting that as much as we can.
How about you, Naiomi?
As I said in my presentation, I think it's just giving us some space and some room around 9124 and allowing for Indigenous jurisdictions and, coming back and dealing with the recognition of Indigenous sovereignty.
Okay, thank you. And when I look at the clock, I apologize for taking that first question. So maybe I'll just ask if all of our question askers could be brief given the time that we have. But I'd love to hear from maybe Peter Carver to begin.
Peter Carver. I'm with the Faculty of Law here at the University of Alberta. Excuse me. I will try to be brief, and my question, I think, is mostly directed at Ryan. In terms of the duty of consultation, we've had recent cases, of course, this summer. And I just would ask for your response to this in terms of sort of seeing the development of that duty and where it's going, and some of the things you said. I mean, although we now scrunch the years together, and it seems like a short time in some ways, we had Sparrow, we had Delgamuukw, and then Haida. And I think one way to see what's going in those cases as well as others is the Supreme Court in dealing with cases out of BC, which, as we know, is a somewhat distinct problem in this area, encouraging the parties to get on with negotiations and move forward with treaties and modern treaties to resolve issues. And maybe doing that with a sense of optimism, and maybe creating a duty of consultation as an interim response, rather than, let's say, leaving it up to First Nations to seek injunctions to stop developments from occurring pending litigation. But with some optimism that that's going to help spur the treaty negotiation process. Now years go by, that process doesn't seem to make much headway. Treaties aren't getting signed, regardless of who may be more or less responsible for that, but the parties are kind of locked into an endless discussion about the duty of consultation. And I just wonder if you could react to that in terms of maybe what we see going on at the Supreme Court around the duty, or where it's headed, maybe even in terms of process and substance. Thank you.
Thank you for the question. I think that you summed up the court's hope very well. The duty of consultation and accommodation was put in or declared by the court because the Crown was arguing that we don't have to do anything as long as rights are not established, so they had no incentive to come to the negotiating table. And the court thought that putting these procedural duties in place would bring some balance into negotiating power. So to my mind, I still see the biggest failure there is that the Crown said, okay, well, we have to consult and accommodate, but we can always act if we feel we've done enough. And if the court were to continue in the line it's taken and say, well, what next step can we take to try to bring further balance into negotiations or set the stage for negotiations, I think one obvious step is to say there has to be some review of proposed infringements before they take place. And I said one way of doing that might be independent commissions. I think in the most recent cases of Chippewas and Clyde River, you see the nightmare version of that. So I mean, the law, the devil's always in the details. If the independent commissions were the NEB and the court said, well, the National Energy Board can do the review before proposed infringements take place, I don't think that's a very satisfactory way to proceed. So I think you need some mechanism of review before proposed infringements take place, but the details matter a lot in terms of how that is carried out.
Good morning. My name is Uhuanes. I'm also known as Eric Shirt. I'm from, my card says I'm from satellite First Nations. That's up there close to the Happy Hunting Grounds. Actually, it's Saddle Lake. But one of the things, I liked what I heard. You know, it makes me think, but also it gives me a little anxiety too, mainly because of discussions. I was brought up by my grandparents, and all I remember was that we were governed by values. I like the business of building on a charter of values. That's why I was really, excited about that idea. And the values are really important. I mean, it was talked about and it was lived, and it was, we didn't talk about any laws and stuff like that, just the values and what they did in terms of how we behaved. But what I want to talk about has nothing to do with the sympathy card. This is just a reality card on our reserve. And in terms of the situation, you have 80% unemployment rate. You have people living in poverty. 60 to 70, 90% of the people are living in poverty. And this former chief of mine, Eric Large, asked me to look at the life expectancy numbers, and it was very difficult to get. But when I did get them, what we found was over a 5-year period from 2011 to 2015, the average age of death for women was 50.1. For men, was 46.4. But one of the things that jumped out from all those records, in terms of names, in terms of date of birth, was what they call same-day deaths. I think they used to call them stillborn. And if you really think about them, that's really all about failure to thrive in the womb. So what we talk about in terms of resolving the health in a community, I think, are indirect approaches. Housing, education, all that stuff. The direct approach is something else. I won't cover it, but it's not always simple and easy to implement. But it's not even in the radar. But the people are not even in the radar. You think about the legislation that we come out to try and resolve these things, including Jordan Principle. Good, very good. I'm glad it's being looked at. But look at those stillbirths. In Saddle Lake, it was 60 per 1,000 births. In Pakistan, which is the worst country, it's 40 per 1,000 births. That's failure to thrive in the womb. But the other thing you have to remember is that it's in a spectrum. You have the worst situation here, you have optimal health over here in terms of a kid being born. But there's a spectrum. But there's a lot up here. What you see is a lot of people being born with that are really malnourished babies, and going to have a lot of health problems down the road. How do they participate? But more importantly, how do the women that are, seriously affected participate? You think about it in this sense. If you're in Saddle Lake, you're on welfare, you get $304. Exciting, eh? How long could you live on that? If you're a woman with a baby, you get $100 and some extra. But if you get your kid taken away, he has a better life. Why? Because they pay somebody $200-300 a day to take care of him, but they won't help the mother. Okay? So there's some injustice in that. But let's see. When you look at these things, all I talked about, in terms of housing, education, all those things are indirect approaches. Okay? What we need to look at is really the direct approaches, but also the rights of those women. Because that lifestyle that they have, that's addiction, mental health problems, poverty, those are the things that put them at risk. But there's no services available for them. I was in Cold Lake at a pregnant woman's shelter. And the lady there says, 95% of the women that come here do not know what resources are available for them. And you take a look at that 80–90% poverty rate in my reserve, what percentage know what services are available for them? Or even if the services are there. And the other one is access. We have roads there. We call them swamp. Come to my place to the paved road, I have to fall 4 swamps if it rains. I mean, it's just a horrendous kind of situation. But the problem isn't, it's like, for that woman, how do you provide them? How do you help them? One of the things that we know is that people who have mental health problems, people who have poverty, people who have addiction problems, they don't like the misery that it brings. They don't like seeing their kids. They don't like going to jail. They don't like going hungry. But they do. And yet these are recognized as health problems, diseases. And yet there's no kind of availability of services to bring them out. Even in the area of poverty and that welfare stuff, it's like trickle-down effect. Poverty isn't about motivation, it's about lack of money. Yeah? Really, when you think about it, and you take a look at these situations on these reserves, with the individuals that are, and the mothers, and the young women, that are losing their kids. I mean, when I look at the obituaries of those stillbirths, you don't want to read them. But how was that created? How was that created? It was created by our laws, Canadian laws. How do we correct it? Is it something that's a national emergency? Is it? But you really think about it in the sense that, it's a national emergency. Okay, thank you.
Thank you for that. I'm just looking at my watch, and I want these conversations to keep going, and I apologize for those that still have questions, but I thought maybe just to send us on our way to lunch, I just asked Naiomi to just close us.
Answer that question or comment on and thank you so much for raising that, and I think that gets to the same point that the elder yesterday, the challenge that you gave us yesterday to think about before we leave. I mean, what you described are significant human rights abuses, right, that are not just the legacy of Indian residential schools and colonialism, because it continues to go on today. It is the chronic underfunding, known chronic underfunding of not just child welfare services, but social assistance. We did a research project in Atlantic Canada this summer, going and actually digging in on reserves. On reserves in Nova Scotia and New Brunswick, the rates haven't increased in 26 years. They haven't even increased, not even by 2% once in that period of time. So there are significant human rights abuses that are still going on under our noses, and we're having these constitutional discussions, but I think, going back to my presentation, that this is part of the neglect and the deflection that continues to happen, and we do need to find solutions and to be aware of them and, figure out collective ways to say that this is wrong and this shouldn't be happening in 2017. So thank you so much for that comment.
If law is about justice, then you have to confront the injustice that we still see and live around us. Thank you to that extraordinary panel. Will you help me in thanking them for closing us so strongly?